Nicola in the matter of the claim of the application of Roehrig and the Secretary of State for the Home Department, Part Head.
Thank you. Mr. Blunder.
My lady, just to recap yesterday, I finished by answering my lady's question about the ability of EU nationals ever to be settled. My lady will recall I took the call
Yes.
and 255 of the rules. That's just a reminder, of course, of where we've got to. The only other point to make on that matter is, of course, it's worth remembering that there's nothing to stop EU nationals, if they wanted to, from applying for settlement or applying for indefinite leave on some other basis. The effect of Section 7 of the 1988 Act is to remove the requirement for leave to enter or remain in the United Kingdom. But of course, they're in no worse position than anybody else. They can apply under a different provision of the rules if they so wish, and particularly, of course, if they fall outside the definition of qualified person. Qualified in the way, the usual way, but no disadvantage from anyone else in that respect. I said yesterday.
Can I just ask before you
Yes.
move on? So, if a protected person lost their protected status but had arrived and been permitted entry,
Yes.
because they should under the rights of free movement and employment, but lost their protected status subsequently, not through accident or ill health or retirement. You say, well, they could still, in country, make application
Yes.
for permanent residence.
That's right. So, for example, there are, as the court will know, a number of different categories under the rule that could, in principle, arise. Domestic violence concessions, the family appendix to the rules.
Yes, and also, for example, if we were met with a situation, and this is one of Miss Seymour's points, if you were met with a situation where if the Secretary of State was wrong for 17 years, and there were a multitude of people who had been granted passports who now face the prospect of them being removed, they would have a very good entry point into different aspects of the immigration scheme.
Certainly. If the Act hadn't been passed, one can well imagine arguments based either on them saying, well, nonetheless, I satisfy some other category now through long residence. Or, for example, there might be, if removal action were attempted, there would almost certainly be arguments about legitimate expectation. And so on and so forth. It's a bit difficult to predict in advance precisely how they might develop, but it's not difficult to predict that those arguments would be
right.
I would have some bite. But yes, certainly they could apply in different capacities. So, my lady, I hope that answers my lady's question. I was proposing then to continue with the 3 points, but much more briefly. I dealt with the first one yesterday. The second and third, having reviewed it overnight, I can really just outline because we've covered the matters already in submission. The second one was to make the point that just because the restriction in this case has its foundational source in EU law does not make it any less of a restriction for the purposes of Section 15 of the definition of settled. And I had in mind particularly there the passages in Abdi Rahman that I took the court to in opening, which explained that it's member states to make their own provision for immigration law, paragraph 18, paragraph 19, and one starts by looking at the domestic provision. So we say therefore nothing to that. The third and final general point was to make this submission, even if EEA citizens, EEA nationals have, as is the case, rights that have not traditionally been accorded to other nationals of other third countries, that does not place them, for that reason alone, in a special position under the 1981 Act, or alter the nature of the term restriction as applied by that Act under the immigration laws. They certainly did have a privileged position in terms of their ability to enter the UK and exercise free movement rights here, as in all member states. But we say that didn't extend to there being any special provision in terms of citizenship. In a sense, that stands to reason from the very absence of such provision in the Act itself or in the legislation. So that really is our positive case on ground one. What I was proposing to do for the remainder of the time on ground one was just briefly to show the court how the judge dealt with it, given it's obviously a decision challenge, and then to pick up some of the remaining residual arguments that the appellants have made against the Secretary interpretation. So can I ask the court just to begin by turning up the judgment in the core bundle. To recall, it's behind tab 8, begins at page 67.
We don't have tabs in the core bundle.
Oh, I'm so sorry, my lady, I should remember that. Page 67, my apologies. The relevant passage is at page 70, it begins at page 79. And towards the bottom of the page, the court should see the heading, bold and line, where the M, that's the mother, was subject to restrictions of immigration. So the way that the judge deals with this is as follows. He notes, as a matter of fact, to begin with at paragraph 79, that the mother, between her entry and the claimant's birth, had a qualified entitlement to remain here, and he states where that comes from. Then he poses the question.
I'm so sorry, my paragraph 79 on page 86.
My lady, I'm sorry if I said 79, that was my mistake. 49.
No, I probably misheard, I'm sorry.
No, it's my. I'm so sorry, my lady. My mistake. Paragraph 49.
Oh, it's page 79.
Yeah. My apologies. So the heading there is whether M was subject to a restriction of immigration laws. He states the basic facts and then asks the question, was the requirement that to be entitled to reside without leave to remain and have to continue to be a qualified person a restriction under the immigration laws? He then proceeds at paragraphs 50 through to paragraph 74 to deal with the cases of Caporelli and Gal. Now, I'm taking this very shortly. The short point about Caporelli and Gal is that neither of them binds this cause. And in essence, all they do is rehearse the arguments that have been advanced by both parties in this litigation. There was, as the court will have seen, a question about the status in terms of precedent of both decisions below. And we'll see how it's been resolved by the judge. And he rightly considered Caporelli to be a decision of coordinate jurisdiction because it was the upper tribunal. Gal, although it's the equivalent of the upper tribunal in the old days, it doesn't have the same status. And he made that point. We accepted that. Nonetheless, that doesn't really tell you whether the decisions are right or wrong. In any event, they don't bind my ladies and my lords. So I wasn't proposing to go through those decisions in any detail. They're dealt with in our skeleton arguments. And if I can give you the reference and just show you how we deal with it there. They're dealt with in the skeleton, beginning at page 61 of the bundle, paragraph 55. And perhaps just for speed, I can ask the court to read 55 through to 61, which is essentially our case on them, if the court is interested.
Well, you basically you support the reasoning of the judge.
Yes, exactly. Well, that's really it. As I say, given that they don't find the court.
I don't think we can be that dismissive about the views of Mr. Justice Nicola, though, can we?
Well, except that, and I appreciate he's president of the tribunal at the time, president of the immigration chamber at the time.
Yes.
However, either he's right or wrong about the law,
Yes.
and we say he's wrong, and indeed it's not just us that say he's wrong. The little friends also accept that he went too far.
On a different point.
Yes, but equally it does show that the decision is a difficult one. And what's more, and the point we made below and we make again here, it was a decision made without the benefit of any adversarial arguments. So he notes, and the passage is identified by the judge, he notes that neither side had dealt with this. Essentially, he found Gal, which is not an important decision, on his own afterwards, and reached his own conclusion about it. So we say for a host of reasons, meaning absolutely no disrespect, and if I was dismissive, I apologise, I wasn't meaning to be at all. But without meaning any disrespect to Mr. Justice McCloskey on that occasion, we say didn't get it right, but for understandable reasons, because he didn't have any arguments directed to the point before him, whereas Mr. Justice Eyre did, and this court now does as well. So
Well,
that's what we say.
Mr. Justice Eyre was very appropriate in his response to the arguments, both of which sought to cherry pick parts of the judgment. So you blame Miss Simon, but I'm afraid, Mr. Blundell, you had a go at it as well.
Yes,
But the judge found his way through that by paragraph 73, didn't he? Saying that he found part of the judgment a little hard to follow,
Yes.
but then went on to indicate that the regulations did not, the 2006 regulations did not apply to the situation in 1986.
Exactly.
So he tiptoes his way around that.
He does, but appropriate tiptoeing in my submission is essentially what he's saying is that the legal position is different now. And the position for this particular appellant, whatever it was, I think 1986 when the period in time was relevant for Caparelli, whatever the position in 1986 before the latest provision of the rules in question, before the 1994 order, and before certainly the 2006 regulations, it's different now. You have the immigration regulations.
Whilst we're on the point, Mr. Blundell, and I'm sorry to take you off course,
No.
I wonder if I could please ask, in due course, that Mr. Berry, Mr. Hapters-Lazi, Mr. Chapman and Ms. Smith get together and provide for the court a chronology of all of the regulations that have emanated since the 1971 Act. Would that be possible, do you think?
Certainly, yes.
It would be very helpful,
Yeah.
because there's a very helpful chronology of events
Yes.
that's provided in the core bundle. But if we can fit in all of the different regulations as we're looking at these authorities,
Yes, of
that
course.
could be very helpful.
My
So
lady.
just whilst you remind me.
For your assistance, it's in fact done in our skeleton before the High Court, which is at tab 13 from paragraph 21 onwards.
Don't give me the tab, give me the
Sorry, page 127.
127. I thought I'd seen it somewhere, and if it's there, paragraph,
Page 127, paragraph 25, or you can go just before that to 21 really onwards. Oh, perhaps we should actually.
it would be
create
better.
one that's a proper
Yes,
chronology.
please. Yes, please. If your learned juniors wouldn't mind doing that, that would be very helpful.
My lady, given that the basis as it is there, maybe that we can agree it relatively quick.
I'm sure. Thank you.
Thank you very much. So, my lady, yes, exactly. The point that he makes, really reflecting what my lady has just said, is the law is different. He's examining the regulations today, and that we say is clear. He then, after dealing with Caparelli and Gal, at paragraph 75 to 81, considered the cases of Cabal 1 and Cabal 2 from the CJU that I was relying on, and it's me that he rejects. At that stage, he said he didn't find them of great assistance.
And do you seek to resurrect them?
Well, I was proposing to take the court to Cabal 2 under ground 2, because I think it might be of assistance for the court to see what the European Court said there.
All right, but we'll get on to that in due
Get on
course.
to it, exactly. But no need to look. And then that leads to, I think another of the reasons my lady Davies said yesterday, paragraphs 82 and 83, and that's really the rationale for his conclusion of 84. And you'll see from 82, he finds that the regulations, the immigration laws, for purposes of section 51, are a law for a similar purpose, and the relevant purpose he identifies there is that of the 1971 Act, is that of making provision for the circumstances in which a person who is not a British citizen may enter or remain in the UK. The 2000 regulations are clearly for a purpose similar, namely providing circumstances in which a particular category of person is not British citizen and derived rights from the EU to remain in the UK. Well, that, we say, accords with the analysis I presented yesterday for the purpose of the Act and indeed of the EU regulatory system. And then he deals at 83 with the fact that the regulations are giving domestic effect to EU law. He doesn't accept that analysis. He said it's important to note that the requirement is for similarity of purpose, not identity. He then deals with the Section 2 ECA argument, deals with purposes, and said it's immaterial. The law in question has other purposes and meets other needs. The one purpose of the regulations was that of regulating the circumstances in which those persons could enter or remain. That's a similar purpose. So that's how you get to that. That's the essential reason for those points. My Lord, what I'm proposing, and we fully support that, we say that is correct in every material respect. What I'm proposing to do next is just to deal finally under this head with the remaining points of objection from the appellant. I'll just take a few of them.
While you're in the judgment, though, do you want to say anything about Miss Seymour's criticism of the judge's reference in 87
Yes.
to the 2000 regulation?
Yes. So that was one of the points I was going to come to, Mark, but let me deal with that now straight away. We say he didn't get anything wrong there. You just need to slightly unpack what he's saying. So perhaps the court turn to paragraph 87. So page 88. What he says there is this. One over can really be seen as a material difference between the circumstances of the two categories of persons and the considerations that apply to those categories. The first is a group of persons who are expressly exempt from the provisions of the 1971 Act, either by the terms of that Act itself or by virtue of an order made under it. I should say, of course, here he's talking about the effect of Section 8 of the 1971 Act. So the order would be an order made under 8.2, and the express exemption would be the exemptions for diplomats in 8.3 and visiting forces in 8.4. And to whom no further restrictions apply. That's a point I'll come back to in a moment. Other than the need to meet the qualification for exemption. The second category consists of persons to whom the leave to enter and leave to remain regime of the 71 Act does not apply by reason of a different express provision. And he says, brackets, in the case of M, the 2000 regulations, and as I understand it, that's what the Simon says is the wrong reference. It should have been Section 7. In my submission, what he's doing there, you have to read the words that come before the brackets by reason of a different express provision. The point he's making in brackets is there is an alternative regulatory scheme for those people. He's not ignoring Section 7 because he'd already referred to that in
this paragraph.
Exactly. And if he sets out Section 7 full at paragraph 31. So certainly that might be what could be classed as an infelicity of wording. I can see why the submission is made, but in my submission it's not actually a good submission. So that's that one dealt with. Point 1 of the appellant is that the EU nationals are wholly outside the scope of the 1971 Act regime, so can't be subjected to a restriction in the period for which they're able to exercise the right to reside. Well, as to that, we say that's the wrong way to characterise the EU national exemption in Section 7. Section 7 doesn't take them outside the Act as a whole, it takes them outside the leave to enter the main regime, but then provides an alternative system of regulation. And in those circumstances, that then leads to equivalent restriction definition of Section 50. That's point 1. Point 2, Malone Friend's argument that references to laws for similar purposes is to catch the position in the islands, the Channel Islands, for example. As to that, we make two submissions. One, quite apart from the difference in wording between the groups in question, the key, 3 points rather, not 2. The first point is the wording is wider than just catching those in the island. The fact that the wording, similar provision, could capture different means of treating EEA nationals in the same way does not, we say, have the corollary effect that it was for no other purpose. In other words, the wording that Parliament has used is much broader than the narrow purpose which my learned friend ascribes to it. So yes, it could capture the position she said, but it does much more than that, capable of much more than that. The second point is that if that was all that was intended to be done, then it's surprising that the parliamentary draftsman wasn't rather more specific. That's the flip side of the first submission. One would have expected that very specific purpose, catching the different legislative provision in the islands, to be specifically identified, given that the islands were defined in the statute already. It would have taken very little indeed for parliamentary draftsmen to add the extra words and say, and just for the avoidance of doubt, it's done in a different way in the Channel Islands, treated in the same way. And then the third point, in fact, properly analysed, the scenario my friends envisage would not be a case of different laws existing for similar purposes. It would be for the same purpose. It would just be a different legislative way of doing it. The purpose would be exactly the same. So we say that doesn't really seem to meet what those words are actually getting at there. But the short point is that the words can't be restricted in that way at all. Third point, my ladies, my lord, is about the effect of the exemptions in section 8 of the 1971 Act. And as I understand it, the appellant argues that because the two exemptions in section 8, or 3 if one counts section 8 as well in the order provision, because they are not being treated by settled by virtue of section 53, then by inference the position must be the reverse for EEA nationals who are also taken outside the scheme of part of the Act, albeit by different statutes, but don't have any reference made to this end in section 50. Well, we make two submissions in response. First of all, the key difference, to pick up a point made in argument by my lord yesterday, the key difference between the groups in section 8, the diplomats and visiting forces, and EEA nationals in section 7, is that apart from the use of different language, the section 8 groups are not subject to any alternative regulatory provision. So EEA nationals are, of course, subject to a very detailed system of regulatory provision under the EEA regulations. So in circumstances where that's the case, we say very difficult to see why Parliament would have intended those people subject to another detailed regulatory regime nonetheless to be treated silently as settled. That position is much more likely to be the other way around. And then secondly, irrespective of that point, even if Parliament could have amended the 1981 Act when enacting the 1988 Act and taking EEA nationals out of the scope of the leave to enter and remain regime, which plainly it could have done. Obviously, it could have changed section 50 and made express provision for it. It did not need to. The whole point is that the settled provision and definition in section 50 has to be met in any event. And so one has to analyse the position, the legal standing of EEA nationals as against that definition. There's nothing in section 50 that says the only exemptions effectively, or the only people who will be treated as being not settled are those who are identified in the exemptions. That's not how it works. You have to satisfy the definition in the first place. So in a sense, there's more than one legislative way to skin a cat. I think that was my third point in response to the appellant's arguments. Fourth point in response. My Lady Justice Macur made a point yesterday, or asked a question about section 7.2 of the 1988 Act, which of course enables the Secretary of State to allow people to enter by order, and asked what that was really designed to do. As to that, we say because there were only limited treaty bases, particularly in 1988, before the development of much of the case law on citizenship and the Maastricht Treaty, which developed citizenship provisions, because there are only limited treaty bases on which one could enter as an EU national, it would make sense to have at least a wider power available, if needed, to allow other categories of person to enter lawfully, notwithstanding that they might not be exercising a treaty right in the classic sense. The treaty rights are actually quite broad because of their interpretation by the European Court. So, for example, service provision also includes, as my learned friend rightly said yesterday, receipt of services, so it covers holiday makers, that sort of thing. So there is a wide range of bases on which EEA nationals were always able to enter the UK, but they were defined. So it would make sense at least to have the ability to broaden out the scope of those provisions. Fifth point, it's said against us that I don't think this is really terribly relevant, but it is nonetheless important that I just make the point clear for the court's note. But it's said against us that we've changed our position on the effect of Regulation 8. And you've heard submissions about that yesterday. We say that's not correct. Our position's always been clear on that. Can I just refer the court to the summary grounds of defence, just to see how we put it. They begin at page 166 of the core bundle, the acknowledgement of service. The relevant passages I want to take the court to, first of all, page 182. And at page 182, the court will see at the top of the page, paragraph 22. It says this: furthermore, the claimant is quite wrong to suggest that the effect of Regulation 8 is to cut down rights contained in the BNA. The essential question is whether the secondary legislation is consistent with the will of Parliament. There can be no question of the rights in primary legislation being cut down here, still less they've been cut down in a manner which Parliament would not itself intend to admit. There's no submissions made about the effect of the regulation, including Regulation 8, having consequences for the application of the Act, and so on and so forth in page 22. And then similarly, at page 189, paragraph 49b, Regulation 8 properly clarified as a matter of domestic community that some categories of national EA nationals were entitled to remain without time restrictions, some were not. It had consequences for the application of BNA, but didn't modify the meaning of the statute. It's always accepted that by the secondary legislation didn't modify the meaning of the Act. The submission was that Regulation 8 clarified the position, no more. I'll say to cut down the rights in any way, and it couldn't. Then, my lord, just two final points on ground one. One, just really for the court's note. Learned friend made the submission yesterday that the rules could come within scope of immigration laws in section 53. Just to be absolutely clear, there's been a lot of litigation in this court and beyond about the status of the immigration laws. I'm sure again the court has come across in the past. The leading case is a case called Order of Eyre. That's not in the bundle, but the same point that's made in Order of Eyre about the status of the rules is made in one of the cases in the bundles. That's the case of Volker. And I just asked the court to turn that up just briefly. The headline submission is that the rules, and this is Lord Brown in Order of Eyre, are a statement of the Secretary of State's policy as to how he intends to exercise his discretion to grant leave to enter or remain at any given point in time. And for a long time there was a debate about whether they were quasi-legislation, whether they were a hybrid form of legislation, whether they lay somewhere between legislation and policy, in part because of the unusual provisions for their role before Parliament. But the provision is encapsulated in Volker, which is behind tab 24, the authorities bundle, begins at 211. The relevant passage, just for the court to note, there is a summary we've referred to, which is sidelined at page 223. I referred to that in argument yesterday. I'm not going to take the court to that now, but that summarises how the UK sought to implement EU free movement rights. Over the page at 224, at letter C, below letter C, you'll see Lord Hoffman there says, there was however a problem about how the Home Secretary was going to implement this policy. The rules are merely a statement as to how the powers in the Act of 1971 will be exercised. See section 3.2. Cannot create a power to require people to leave which does not exist in the Act itself. So, for a different purpose in that Act, but that, particularly the start of that statement, is an accurate statement of the status of the rules. Doesn't mean that for the purposes of section 53, they can't amount to immigration rules, and that's why I've taken an objection to any other friends to put it. For example, at one stage in the Immigration Acts, the immigration laws for the purpose of the immigration appeal rights under the old appeals regime were treated as being part of the law. So they are treated for different purposes at different times. But I wouldn't want the court to be under any misapprehensions to the general position as to the rules. It doesn't matter for this case. Nothing turns on that here. But again, just so the court has the position. And then the second point, final point to make on round one, is just to deal with two things I said yesterday I would do. Can I hand up, with apologies, we've done it in as short a form as we can, an extract from Bennion that deals with 2 points I said we'll come back to the court on overnight. One is the use of guidance to interpret legislation, and the other one is the approach to the 2023 Act.
Yes, thank you.
Those matters that came up in our
Ms. Seymour, have you had this?
do we have? They have. 2 seconds.
Thank you.
You'll see it's an extract from Part 7 of the external construction. The first passage, page 804 at the bottom of the page, is from section 24.17, headed Guidance and Official Statements on Meaning of the Act. Again, it's a sideline passage. You'll see that whatever weight it has, guidance is not a source of law and cannot alter the true legal meaning of the statute. So I refer to some case law that effectively says the same thing yesterday, and it has a context of statutory construction. So in the context of statutory construction, it has no special legal status, and obviously no support for the judiciary, not the executive to determine the meaning. Guidance that tries to explain what legislation means, given no more weight than the quality of the reason contained in it deserves. It's wrong, or would say so. Guidance which is consistent with the view that the court is, in any event, inclined to adopt, the court may find it some reassurance. That's about as high as it goes. And then one has an extract there from the judgment of Mr. Justice Lord Jones as he was in the Ellis case, which comes to the same view. The purpose of going to that was, as I say, because I indicated yesterday, I'll come back to the court on that, and it was relevant to the Stevens case, the Bermuda case. Can I just show the court, and we'll get that point out of the way, how the guidance in Stevens was dealt with by the judge in that case. Stevens is behind tab 36. And if the court turns to the very last page of the report, page 623, you'll recall the guidance in question that the court was using here with the nationality instructions. And you'll see there's a heading conclusion, paragraph 53. It says he agrees with Chief Justice Kowali that section 27A of the Act permits the applicant to remain for an indefinite period, may be brought to an end in those circumstances. He then says this, but in light of the nationality instruction, I respectfully disagree that section 27A is a restriction of the immigration laws on the period for which he might remain in Bermuda, at least in the case of someone lawfully present, restriction to a definite period of time. I note that the Chief Justice had not referred to the NI when he made the ruling. Had I not been referred to the NI, I might have been tempted to agree with him on this point also, as his interpretation of para 7C is the one that best comports with the ordinary natural meaning of the statutory language, although the potential far-reaching ramifications of such a broad definition would have been a matter for concern. So it appears that he actually used the nationality instruction, the guidance, to reach an interpretation which was contrary to, in his words, the ordinary natural meaning of the statutory language. So we would say that's not in accordance with
Are we now straddling grounds 1 and 2?
I'm so sorry, man.
Are we now straddling
I'm
grounds 1
sorry,
and 2?
I think strictly that's a ground 2 point. I only came to it now because I'm about to move to ground 2, and I've taken the court to Bailey, but my law's right, so it's a ground 2. But that one now is dealt with and out of the way. Stevens. I don't want to say any more about Stevens. So that's what I want to say about that. The second part of the Benyon extract over the page, at page 808, you'll see the section at the bottom of page 24.9, inferences from later acts. Now again, let me just be absolutely clear about our position. I am not seeking to rely on the 2023 Act in any way in this case. I explained yesterday, it only came to force after we filed our skeleton with our written argument. We're not attempting to resolve that. The position, tending it might be, and the position, as I say, accurately summarised here, but the court will see for itself what's said, is that where there is ambiguity, one may be able to use later legislation in the ways that are outlined there. But I'm not trying to do that. In fairness to my learned friends, we haven't tried to do that before, and they're not trying yesterday. But the court asked the question, and that's why we put it before the court. Can I leave that with the court? I'm not proposing to make any submissions on it, unless it would assist, of course, the court for me to do so. We hope we've sidelined an appropriately broad range of material there, which may be in the abstract of assistance to both
Can I
sides.
just check? We seem to have a quite substantial submission from the appellant, do we, on the 2023?
Yes, so my lord, I'm so sorry, I'm stuck in the occupational hazard. My lord, yes, there's a note that the appellant's provided to us this morning, which we've seen. I'm proposing to let the appellant deal with that. We have seen it, and they make submissions about not taking the 2023 Act into account.
I mean, if you're not taking the point, this is all quite a lot of. I appreciate it that I may have set this hair running. It's quite a lot of effort in relation to something, a point you're not taking.
We're not taking. And I made no distance at all, my own friend. They obviously want to do the same as we do and make sure the court has the right position. But we're not taking.
It's just an oddity. There is now an Act of Parliament which proceeds on the basis that the statute we're looking at
Yes.
has a particular effect, and we're being invited to say that it doesn't. It just seems to quirk to me. Maybe an inevitable outcome of
Yes.
this sort of reactive legislation.
Yes.
In pending an appeal, and it
Yes.
may be no more than that.
And well, that is the unusual context here. I mentioned the word vested rights yesterday because one would have to be very careful in a situation like this where there is legislation which is being implemented to deal with the consequences, not for the individual appellant, but for others, of the meaning which a court has said legislation bears. There would have to be some care taken as to how that legislation is then taken to affect the appellant's position, specifically where it was enacted during the course of that particular appellant's litigation. I'm not saying there are vested rights here, I want to make that clear, but I would anticipate an argument being made on those lines if I sought to rely to any degree at all, and one can understand why. My lord says it's at work, and that's a fair way, respectfully we say, putting it. It is unusual. Not unusual that Parliament, of course, will legislate as an outcome of litigation, one way or another, either to deal with consequential matters, or in some cases to overturn the result. But here, we're in the middle of the litigation. And given that our primary case is and always has been, the legislation is clear, noting, of course, my lord's fair point that it wasn't very clear to the Home Secretary for 17 years, nonetheless, we say when properly analysed, it is clear. And in those circumstances, we don't need to turn to the 2023.
No, but one can understand why Ms. Simon says, well, look, you know, this is pretty defensive behaviour, which rather supports our argument, because they think they've got to do a belt and braces. But that's beside the point. You say just lets us concentrate on
Yes,
what we need to.
My lady, it's important to be clear about what the Act is doing, of course. It's not defensive because Mr. Justice Eyre has adopted a position which the Secretary of State wasn't arguing for.
Oh, no. But it's part of your argument is it wasn't necessary anyway, because it's the judiciary that interpret eventually.
Sorry, no, it was necessary, but to remedy the position that the pre-2000 cohort found themselves in. Sorry if
I
wasn't
see.
clear about
No,
that.
that's my fault.
No,
Yeah.
I wasn't clear on that. So it's not necessary for us to rely on the legislation to make our case about the meaning of the legislation, the meaning it's always born.
Mm.
The problem is the Secretary of State got it wrong. Got it wrong for 17 years.
Mm.
And got it wrong in a way that meant that people thought, and were told, not just thought, but were told, and had it confirmed by the official authorities, that they were British citizens. And an awful lot flows from that.
And of course, nothing would ever have been brought to the court.
No, exactly. If, of course, Secretary of State said, well, actually, you're not a British citizen, then somebody might then have gone to a court, and you might get the sort of defensive legitimate expectation arguments being raised at that stage. But that would be very much the shield. One can't rely on that as a means to cure what would be a very potentially very big cohort.
How many Secretary of States were there in 17 years? As a matter of interest?
That would be, these days, that's probably an impossible question to ask. But between 1983 and 2000,
Quite a few.
yes. If my lady's interested in the answer to the question,
No.
I can find out,
It's
but quite a
only
few.
as a purient interest, I'm sure.
Yes.
But in that period of time, there was, of course, a change of government, wasn't there?
There was.
Yeah.
There was, exactly.
So no colour can claim to have the
No.
high water mark.
No, exactly. Certain immigration consequences will be tied to one or other political regime, but not here. So it's a consequence of Secretary of State's interpretation being right that these people in the pre-2000 cohorts are therefore affected, and that's what Parliament is curing. I think if I go much beyond that, I'll start to say things that will be seen as a submission.
Yes, of course. So the change in understanding is highlighted for the first time in this case, at this level.
Yes, at this level, yes.
Yes.
Yes,
Yeah.
yes, this is the first time this court has had to deal with this particular issue.
Thank you.
So, unless I can assist the court further, those are my submissions on ground 1. Ground 2 I can take much more quickly.
Are you okay on ground one?
Can I just ask one thing?
Yes.
Sorry to go back to paragraph 87 of the judge's judgment.
Yes.
I think I may have misread. The point is that the judge in the middle of that paragraph, the way he expresses it, it sounds as though, this is Miss Simon's point, he thinks that it's the 2000 regulations that provided the exception. That's the point.
Yeah. Yes, that's
And you say that's a misunderstanding because the judge has already referred to section 7 of the 88 Act.
Yes.
Where is that?
Oh, I'm so sorry, my lord. I thought I said it's in paragraph 31, page 75, and he sets it out in full.
You did say it, I just couldn't remember what you said.
Yes, I'm sorry. He may refer to it elsewhere, but certainly he sets out the provision in full there.
Yeah. But he strangely doesn't refer to it. He refers in 86 to section 8 of the 71 Act.
Yes.
In relation to the other exempt persons. He doesn't then refer to section 7.
He also refers to section 7. If my lord looks back at page 85 and paragraph 74. So he's dealing here with Mr. Justice McCloskey's judgment in Macur. Mr. Justice McCloskey was aware there had been provision by way of regulation addressing rights of citizens, however the legal regime applicable in October 2000, which I have to consider were very different from that prevailing in 1986, with which the judge was concerned. In 1986, the treatment of EU citizens was addressed by way of the grant of leave to enter and remain under the immigration rules. From 1994 onwards, position had been governed by section 7 of the 1988 Act.
And the 1994 Act, and in October 2000, the latter had been replaced by the
Yeah. So he's aware of the chronology, he's aware of the correct statutory regime, he's got it in mind.
Yeah.
And certainly, I don't suggest other than this is an implicit reasoning, an implicit wording, it could have been better expressed.
Yes, and you agree it might have made more sense if in that bracket, but
Yes.
section 7.
Exactly. But my submission
Does that make any difference?
exactly. A, does it make any difference even if the submission's right? No, it doesn't.
Yes.
But B, actually, if you read the whole thing thoroughly in context, it's clear he was aware of how it all worked. And that has to be where the submission goes.
Yes, thank you very much.
Great. So, ground 2, the appellant, of course, argues that even if the restriction that arises from the qualified nature of the EU rights to reside is a restriction on immigration, it's not a restriction on the period for which he can remain. Well, we make 2 submissions. Submission 1 is that the text of the Act is against and submission 2 is the authority from Kurasu is against it. The starting point in textual terms, while submission 1 is again the breadth of the statutory language. The words used are any restriction on the period for which he may remain. And again, pausing there and thinking about the degree of connection required to establish citizenship, which once established the rights as a matter of law with all the consequences that follow, understandable why Parliament would be keen to catch a wide range of provisions which effectively meant that your position here was contingent in some way, and that you weren't here forever, and wouldn't therefore have the degree of connection required. So the purpose of having a broad approach using the term restriction, any restriction, we say is clear. The focus is a functional one. It's a restriction that has to be identified, not a time limit per se. And a restriction has to have the functional effect of limiting the period for which someone may remain. So it's not just type of restriction, it's any restriction. Of course, if Parliament had wanted to catch just a narrow time limit, properly so called, so in other words, wording saying you may remain here for 6 months and no longer, nothing would have been easier than to use that very terminology, but it didn't. A point my learned friend makes is that restriction is the language of conditions attached to grants of leave under section 3 of the Act. We say that's not the right way of looking at that at all. Can I ask the court just to turn up section 3 of the 71 Act again? In the version, of course, at the relevant time, it's behind tab 4 of the authority bundle. And page 19 is where it begins, where section 3 begins. So actually, if one's looking at the language used here, one sees section 3.1. Steps otherwise provide by the Act, where a person is not a British citizen. B, he may be given leave to enter the United Kingdom, or when there, leave to remain, either for a limited or for an indefinite period. And then C, if he's given limited leave to enter or remain, it may be given subject to following conditions, namely a condition restricting his employment or occupation. So the language of restriction, which is the language used in relation to immigration in the 1981 Act, actually takes the broader language relating to conditions restricting employment or occupation. So if Parliament was being influenced by anything, it was being influenced by the broader concept of a restriction on the purposes for which somebody was there. To that point, we say it tells in our favour.
Can I just go back one, Mr. Blundell, when
Yes.
you spoke of the functional effect of limiting the period? I mean, that really goes to the analysis that you say has to be carried out in respect of the individual who is here, looking at what they are doing.
Yes.
Picking up the point made by my lord yesterday that it is probably for an indefinable period, and therefore one really does have to analyse precisely what is there on the ground.
Yes, my lady, I'd accept that. And of course, within EA National, although it's an indefinable period, because they can have their permit renewed, and provided they are satisfying the criteria for being a qualified person, then they're lawfully here. And although that's indefinable in advance, these are categories which are themselves clearly defined. Yeah. So it's not a huge number or wide range of categories. It's the specific qualified person categories you see in, I think it's Regulation 5, which are set out. So it's not an impossible task. Those are well-known categories in EU law. They're the classic treaty rights exercise categories. And so, yes, it has to be analysed as a matter of fact, essentially, but it will be usually quite a clear answer.
Just looking at the real gravamen of what's being argued against you, doesn't it amount to this? It's being said that somebody who's going to avail themselves of services in the United Kingdom, for instance, coming over for a long lunch on Eurostar, is settled here.
Yes. Exactly.
I mean, that's an extraordinary proposition.
It is. Now, what I think will be said in response is that there's another element to the test, which is ordinary residence.
Right.
So it may be that my Lord's example of the long lunch, which is a nice example, nonetheless may fail on other grounds. But what is important is that, for example, somebody who is here working potentially for a very short period of time may still be able to qualify on the other friend's analysis. Because ordinary residence can be for a short period of time. That doesn't have to, by definition, have to be for a very long period of time in advance. It can be very short. That's the effect of the charge of them that's been referred to. So absolutely, my Lord is, respectfully, I say, entirely right to identify that risk of where the proposition ends.
Can I just look at the other end of the spectrum of that
Yeah.
point? Well, it goes back to something that you responded to a question yesterday. And it goes to the ability to become settled by making an application after 4 years, and the obligation to extend by another year, subject to public
Yes.
policy. On that basis, what is the argument for saying, well, does it really take a piece of paper to become settled? Because if you've got the ordinary residence, as this mother did,
Yeah.
and she'd been here for more than 4 years and could have made the application, your response to me is, well, actually what's necessary, what's important is that there's an ability to verify.
Yes.
Is that the only thing that the application does?
Well, picking up the point that I've just made in response to my Lord's
Yeah.
question, ordinary residence, of course, may not extend very far in the future. So ordinary residence itself tells you what intention how you intend to treat
Yes.
your place of residence.
Yes.
Again, the court will be very familiar with case law. Settlement, because there are two criteria, being settled, that's something else to that. And being settled is adding the essential degree of long-term connection with the United Kingdom that's required to get citizenship. So for that purpose, the checking is actually really important, because having been here, lawfully exercising those rights, is seen as significant. It wasn't, at the time, enough in EU law in itself to get a right of permanent residence. That only came several years later,
Yeah.
the Qualification Directive. But under the rules, the Secretary of State being more generous said, well, I accept you may be here for quite a long time exercising treaty rights. If that's the case, I'll recognise that, but I do want to check you were doing what you said you were doing.
And just suppose that there's an applicant who says, look, check now, but actually I haven't made an application, but you can see that from 2 years ago I was settled. I could have made this application then. Would it really be so black and white? Well, you haven't made the paper application and therefore you are not able to imbue your progeny with British nationality?
But in my submission, the Secretary of State is entitled to treat that as strictly as that, given the consequence of gaining nationality and citizenship. I mean, think of it this way, one of the points I made yesterday.
So it's a proportionate response
It's
to
proportionate.
what's going to...
Exactly. Proportionate response, particularly given two things. One, an EEA national is in no worse position than any other third country national. As I said in opening this morning, of course, they could always apply under a different provision of the rules if they wanted, not prohibited from doing that. They just don't need leave to enter remain to be here. But if they want...
and they could, in fact, apply before 4 years.
And they could, yes, they could if they had a different basis under the rules. They could have done so. But it would depend, of course, on what the rules said at a particular time. But they certainly weren't in any worse position. What the rule did at that time, and that was always the case, what the rule did at that point was to add a basis specific to EEA nationals, recognising that they may be here for some time. But then equally saying it's an important right you're going to gain by doing this, so we're going to be absolutely sure that you're entitled to it. And of course, one of the points I made in argument yesterday is that once somebody has citizenship, it's extremely difficult to take it away. There is the provision where somebody's a dual citizen in section 40 of the BNA, and that's what led to cases like Schulenberger, we'll be familiar with. But the criteria for exercising that are narrow and with high thresholds. Effectively, it's conduciveness to public good or fraud. So once you've got citizenship, you've got it.
Yeah, okay.
May I just turn my back for a moment?
Yes, of course.
The point that's being made to me is essentially, of course, this is also a policy question for Parliament.
Yes.
EU nationals, as I say, are in the same position in this respect as other third country nationals. They're in no worse position.
Yeah.
And Parliament's deemed that to be appropriate. So, I think I've just taken the court to section 3, and I've made the point about the statutory language of section 3 of the 71 Act. That's my point about text. The second point is about authority, and that's Kumarasu.
Right, before you, sorry.
I'm sorry.
Absolutely, my lord.
I just want to, just about the textual construction.
Yes.
As I understand it, when we're looking at ground 2, we must proceed on the basis that the immigration laws include EU 2000 regulations.
Yes.
So we must construe the word restriction in the context of a set of laws which include the EU regulations.
Right.
So in that case, it seems to me you very clearly would look at the restrictions in the 2000 regulations. So in a sense, I wonder, if you win on ground 1, I wonder how much scope there is for ground 2.
Because of the effect of ground 1 on ground 2.
Yes.
Yes. I think that the point made is still...
It's still there.
Yes.
Because their point is that period means time period.
Exactly.
But when we're working out whether that's right or not, you have to look at the fact that there are no time period restrictions in the EU legislation.
Exactly.
Which is included
And
in the immigration laws.
Exactly.
So it seems to me it's certainly a point in your favour.
Well, quite. And again, it would be quite an extraordinary position if Parliament, taking EU nationals out of the scope of leave to enter and remain, as it was required to do by EU law, but not being required by EU law at the time to make any provision for settlement for them, except in the very exceptional circumstance of retirement and incapacity and so on. But if the effect of doing that was nonetheless that, in fact, the inability to impose a time restriction properly so called meant that the qualitative functional restriction that necessarily existed had to be ignored. That would be an extraordinary position, and it certainly wasn't one that EU law required. One might ask in those circumstances rhetorically, why did Parliament think it necessary to have that as a consequence? Plainly not. So I certainly agree. Kumarasu, the court has
Hang
already
on.
seen, just to
Mr.
remind
Blundell, sorry.
Sorry.
Following on from my lord's point, this is on the textual
Yes.
thing. Could I ask you to deal with Ms. Simer's point on the notification letter, page 211?
Yes.
Because she picks up on the period.
Yes. Yes. So it uses the phrase there. This is at page 211.
Yeah.
The 8th red letter. As you were not able to provide documentation to show your mother was free from immigration time restrictions. It's true. It uses the phrase time restrictions. In my submission, it's a letter. It's not a statute. One has to interpret that with a fair eye, given that in EU law you couldn't impose a time restriction. So plainly, when the Secretary of State is writing the same time restriction, what the Secretary of State means is any restriction on the period for which you're entitled to remain. It's a shorthand. Now, it may be that that's a slightly unfortunate shorthand, given the debate in this course, but it may be that the caseworker sending the letter didn't necessarily anticipate that wording would be pulled over here. Certainly, if one were advising on the wording to use, one might use different wording. But again, one has to interpret it fairly. It is not able to impose a time restriction. So when it says time restriction, it must Can I just turn my back again?
Of course.
And of course, insofar as the question in this case is a question of statutory construction, then the letter isn't an aid of statutory construction.
No, but Ms. Simon takes the point, and we've got to look at.
Of course. I say just read it fairly and in the context of what it must have been dealing with.
It is possible, isn't it, because of the statutory provision, section 3, to impose a restriction on time by virtue of section 3(1)(b), and the conditions are permissive in paragraph 3(1)(c), it may be subject. So it is possible, it was possible under the 71 Act to provide a time-limited period.
Certainly for non-EEA third country nationals, yes.
Yes, at this time.
Yes.
And it's just that you took us there and said we look at 3(1)(b) and C.
Yes.
But they're not conjunctive, they can be disjunctive.
Yes, that's true. Yes, you might. So you might have. I think the point. I understand the point my lady's putting to me. You might have a time-limited grant of leave.
In which case there wouldn't be any functionality to consider because
Yes,
your
exactly.
leave is for 4 weeks.
Yes,
From the 1st of March till the 1st of April.
exactly. And you might have conditions which say don't work. That's very common. So you can come in for whatever period of time, if you're prohibited from working. That would be a restriction under C1, condition restricting his employment. But my lady's right in terms of limiting the period of time, restricting the period of time. You could do it through 3(1)(c) with an express time limit. But for an EEA national, of course, because of peak,
Yes.
you can't do it. That's the problem, and that's why. And that was the offence, part of the offensiveness of the system that looked at in peak, that the Secretary was granting leave to enter for 6 months at a time.
Yeah.
And the reason why it's offensive in EU law is because EU law looks to qualification. What are you doing and why? If you look at the passage I highlighted in Volcker, what Lord Hoffman says is that's typical of a continental European immigration regime, because there you have land borders. So the question the authorities are usually looking at is, does somebody have the right to be here?
Yeah.
Whereas where you have an island like the UK, you have to allow people in to begin with. So authorities, Kumarasu, tab 22. I agree with my learned friend, it's quite an unusual case in that it involved a grant of leave by mistake. One of the terms of relative leave about working in Sri Lanka High Commission were mistakenly granted. In law, a grant of leave by mistake is still a good grant, provided it hasn't been procured by fraud. That's the effective decision of ex parte Ram that's referred to in the judgment. You'll see the relevant passages are in Sir John Donaldson, Master of the Rolls, at 185. He deals with it all, and then at letter E, he said what matters is this form of provision involves a restriction on the period for which the applicant might remain, namely so long as he was employed with the High Commission, and so prevented his acquiring status of one who's settled. He agreed with Lord Justice Dillon. I should say Lord Justice O'Connor agreed with both of them. Lord Justice Dillon deals with the matter on page 189, where he sets out the arguments, and then at 190, with letter B, he says in the first place they constitute, as I read them, qualification of the permission to enter, which is evidenced by the entry stamp, the applicant was granted permission to enter and remain, only for as long as he should be employed with the High Commission. That was a restriction in the period which he might remain, which prevents him from being settled in the UK with the meaning of the Act and the rules. Now, the court there is dealing with the settlement provisions in the 1971 Act rather than the 1981 Act, but they are absolutely identical. The 1981 Act borrows them in total, and clearly so. In my submission, the decision is binding. Even if it weren't binding, all the reasons I've given, it's plainly the right analysis.
Do you you want to address the per incurium argument Miss Simon made on it?
Yes, so I think that was per incurium because it didn't refer to section 3.
I think she said, in fact, sections 8, 3 and 4.
Sorry, 8, 3 and 4, my apologies.
And section 3 as
Section
well.
3,
So,
3, 4.
yes, let me just
Section
make
3,
sure
4,
that
that's
Section 3, 4 and 3, 1, B and C.
3, 4 and 3, 1.
Yeah.
So in my submission, that's not, it's not per incurium for that reason. Clearly the court was well aware of the power to grant leave to enter and remain. It didn't need to refer to those provisions. Section 3.4, which is the one I haven't been to yet, page 20, a person's leave to enter or remain shall lapse on his own to a country or territory outside the common travel period unless within the period for which he had leave he returns in circumstances in which he's not required to obtain leave to enter. In my submission, that's dealing with a different situation from the issue the court was dealing with here, which was about settlement. The fact that it is possible for leave to lapse, or indeed, and this is another argument for a slightly different purpose that the appellants advanced in these proceedings, that of course even ILR can be lost, if not through lapsing, then through bad behaviour, and the operation of the Act's provisions when it was deported. That's quite different from looking at the position when you have a period of permission to be here, which in some ways limited, and where you have to continuously fulfil the qualifying criteria. Once you've got ILR, you've got it. And you only lose it by doing something new, leaving the territory for a long time, or doing something very bad, which results in being deported. Quite different when you are simply having to fulfil the same conditions over and over again. So in my submission, the provisions in question, section 1, section 3, section 3, 4 in particular, which I haven't dealt with, and section 8 don't take the matter any further. As to section 8, of course, there is the exemption for diplomats that's there, but this was dealing with the effect of a provision which was expressly limited to a particular purpose in the country, and so it's therefore completely on point. But even if I'm wrong about that, in any event, and it wasn't binding, it was very curious, I say the reasoning is still good. I've dealt with the section 8 point already. I've just dealt with the section 3, 4 point in any event. And indeed, in fact, if section 8 is being relied on, then I'm just reminded that actually section 8 is referred to on page 190, just for letter D. So plainly, status as a diplomat was taken into account. And indeed, also at page 189, at letter F, you'll see a reference at the end of the paragraph, section 8.3 of the 1971 Act. And you'll see peppered throughout references to other provisions of the Act, section 2, so on and so forth. But there's no suggestion, realistically, in my submission, that the court wasn't aware of the Act's provisions, even if it didn't refer to each and every one of them individually and how they work. So not and for that reason, of course, we do also say that Stevens in Bermuda was per incurium. It didn't have regard to Conrasic, and even if the doctrine of the use of English precedent was different in Bermuda, it became persuasive at the very least. In terms of authority, the other case I said I would take the court to was Caba number 2. Can I just take the court there now? You'll see it's behind tab 31 of the authority from page 372. It was the second case by the same applicant before Luxembourg Court. I don't need to trouble you with tab 1 for the moment because tab 1 is considered tab 2. In the head note, you'll see the facts are the same. In that case, Kay applied for indefinite leave to remain less than 2 years after he acquired rights of residence in capacity as a spouse of the community national. A number of questions were referred with a reference to paragraph 2.5 of the rules and a contrast drawn with paragraph 387 of the rules, which allowed somebody to be present and settled after only 12 months of residence. The relevant passages, well, first of all, I should show the court in the judgment. The judgment begins at page 409. You'll see the community legislation is set out, then the national legislation at paragraph 6 and following, there's reference to the EEA regulation 2000, paragraph 7, then there's the rules, there's the various orders, so on and so forth, facts at paragraph 17, and then the relevant analysis begins at paragraph 46, that's page 416. Give some context, you'll see it, paragraph 46 begins, concerning the present case, the court held in paragraph 1 that as community law stands at present, the right of nationalism in the state to regard another member state is not unconditional. Some detail given. 47 should be added more specifically as regards the situation of a migrant worker who is a national member state. The right of residence is not unconditional inasmuch as it's subject to the condition that the person remains a worker or where relevant, the person seeking employment, unless he derives the right from another provision. In contrast to the national rules, so the person present and settled is not subject to any restriction regarding the period for which he may reside within the territory and need not during the stay satisfy any condition comparable to those laid down by the British community law. Follows that the right of residence which these latter provisions confer on national government and states is not comparable in all respects to that enjoyed by a person who is present and settled in the UK according to its legislation. And then at 53, this is the response. None of those points invalidates the soundness of the interpretation to the effect situations are not comparable in all respects, inasmuch as a migrant worker who is a national member state must, in order to retain the right of residence, continue to satisfy certain conditions not imposed on a person who is present and settled. No relevance attaches in this regard to the fact that those conditions do not constitute an express limitation on the duration of residence, rationale temporis, or to the fact that indefinite leave to remain may also, in certain circumstances, cease to have effect. The fact that the EA order may apply to UK nationals as well is also material in this regard. It follows that the court's reasoning in Cabot is based on the lack of comparability and not on justification for a difference in treatment between the different categories. And then there's the answer to the question given in paragraph 56. So striking, we say, court applies the same analysis in that context, the significance of not having a temporal restriction, as has been analysed here. Now, of course, the learned judge said, well, I'm not really assisted by that because there's no dispute about the fact that the community right, or the union right, is conditional, in some way is subject to a condition. It's not unlimited. But nonetheless, we do say that it is at least, and of course, he also made the point that Cabot 1 and Cabot 2 are not purporting to interpret and give any definitive interpretation of national legislation. That's, of course, correct. That's not the function of the European Court. But it is relevant, given that this case is about the nature of European rights when they are applied in the domestic context, to see how the European Court interprets it, that exact point.
If a draftsman wanted the state to provide that refer to a restriction on your ability to remain whilst you fulfil the condition, it's difficult to see how they could do it otherwise by saying restriction on the period.
Yes. You normally do. You might normally do it by a time limit and say you can stay for 6 months and you can do these things while you're here. But if you're prevented from saying you can stay for 6 months, as you are prevented from European law, then it has to be in the way that it's done. You're only entitled to remain for as long as you continue to satisfy those conditions.
I suppose what I'm asking is that maybe it's not the right question for you, but I'm just wondering what wording Miss Seymour said would have been used to affect the position that you say it.
Yes. Well, in my submission, it's very difficult to see what other wording could have been used because they couldn't have referred to a time. That's the one thing we definitely know from Peake and Volcker and all those cases. So in those circumstances, if you can't actually have a guillotine effectively and say at 6 months you're done, subject to you applying and getting further leave.
But you have to say restriction on the period.
The restrictions.
Restriction on
The way you have to do it. Yes. And if then, when one thinks of the consequences, when taking EEA nationals out of the regime of leave to remain and saying you can't impose a time limit, you don't have to ignore the fact that their presence is conditional and contingent on them continuing to be qualified in the way that European courts identify. So if you're going to do that, then this is the only way you can do it. And there's simply no reason why Parliament should have intended subsidentia for those EEA nationals just to get out of the 6 month limit suddenly and settled for all the reasons that my law highlighted. And indeed, there's every reason the other way to say we're giving them an alternative regulatory context and regime, therefore they're not settled. And that's caught by the existing wording of the Act. We don't need to amend it. May I just have a moment to stand by? My lord, sorry, I've gone slightly over what I said, but unless I can assist any further, those have been my submissions.
Thank you very much indeed, Mr.
Thank you
Blackwell.
very much.
So, Mr. Berry, no, sorry, it's there's 3 names, but it's Mr. Chapman and Miss Smith, I think. Do either of you follow, Mr. Chapman?
No.
Miss Smith.
My lady, no.
Thank you. And Miss Weston, is she?
Sorry?
I've got Alicia Weston on the advocate.
She was our solicitor at one stage.
Oh, I see.
I
That's
think she's no longer.
yeah. But Mr. Chapman and Miss Smith, we've asked. Thank you.
Great.
So, Miss Seymour. First of all, thank you for this. My lord saw it before, certainly me. I don't know if my lady had seen it, but do we go to the stall or?
I'm going to just, if I can just sort myself out.
Yes, of course.
Then I will,
Yes.
You can less chaotic manner.
Yeah.
My ladies, my lord. On the Act, we've now heard that it's not relied on in any sense. My juniors did a fantastic job creating a really excellent and helpful note, which I thought you might want to see. You may decide that you don't want to see it. Probably you don't want to see it because you've not had submissions in relation to it. Nonetheless, I would like to thank them for that work.
Yes, well, we join those thanks because obviously it was something that we'd asked and been interested in, and we may still have regard to it as a matter of our own interest. So thank you both very much, Mr. Berry and Mr. Haberstalzy.
So I'm going to start just to deal with the case law that's been touched on.
Yep.
First, the case of Davies. Now, we find it difficult to understand precisely the point that was sought to be made in relation to this case. And in our submission, this case is a red herring. It concerned the question of whether the individual could claim a permanent right to residence under the 2006 UK regulations, which implemented the 2004 directive that brought into EU law for the first time a right to permanent residence in another EU state if you had been resident there for 5 years, and resident meant exercising your free movement rights. And therefore it necessarily followed that if it wasn't enough just to prove that you had been there 5 years pursuant to a residence permit, you also had to establish that during that 5 years you were qualified. Accordingly, it followed, and we can go to it, it's in tab 33, page 469. And then if we go to page 506, the material bits that were referred to, it followed first that a resident permit merely certified a right of residence. It was effectively a declaratory document. And I believe I made that point yesterday. You didn't need a residence permit to have a residence right. And effectively, all this case goes to show is that residence permits are mere formalities. Having one does not prove a right to reside, and not having one does not prove a lack of a right to reside. So this takes you nowhere, save to show that insofar as the mother, in this case, of the appellant, is accepted as at all times as having had a right to reside, which is the case, the absence of a residence permit is nothing to the point. So those are our submissions on Davies. As to the Abdurrahman case, we say again, it's a red herring. It is not in dispute, in our case, that the mother had a right to residence. It's also not in dispute that as soon as you no longer have an enforceable community law right under section 7.1 of the Immigration Act 1988, the 1971 Act reapplies to that individual, i.e. the individual is no longer exempt from the immigration laws. So the point at which you no longer exercise your EU rights, you are no longer entitled to claim the exemption in the 1988 Act. And it's perhaps worth looking at the exemption. It's in tab 8. You do not need leave to enter and remain in any case in which you are entitled to do so by virtue of an enforceable community right or any provision made under 2.2. Now, why it says enforceable community right is because even if there's no UK legislation giving effect to that right is enforceable through section 2.1 of the Communities Act. So if you had an enforceable right directly under the treaty or under a regulation that you could rely on directly in the UK, as you could with regulations, or indeed if you had a directly effective right in a directive that had not been implemented by the UK, then you were exempted under section 8.1. The other possibility of you being exempted is you could actually refer to a domestic provision that had been enacted through section 2.2. In any case, the key point is, as soon as you can't show that you've got an enforceable community right, you're subject to the immigration laws. Now, the third case is the case of Cabba 2 that we just heard about. We rely on the ruling of Mr. Justice Eyre below. This case is a discrimination case. It was originally relied on in the High Court as being an explanation of the light bulb moment that led to the 2000 regulations. So it was said by the Secretary of State that after Cabba, they suddenly realised that actually EU nationals didn't have a right to remain here or reside here. They had to be qualified. And therefore, they enacted the 2000 regulations. Now, it's quite obvious that that is a difficult point because it was quite clear to everybody from way back in the 1968 Directive and Regulation, that no EU national had a right to stay in another country and to claim benefits and all the rest of it, reside there with full rights of other nationals until the case of Caba. So that was how it was relied on, but we say it's completely irrelevant to this case. We know EU law rights are not absolute. The United Kingdom knew that EU law rights were not absolute when they acceded to the European Economic Community in 1972, and we do not accept that the Secretary of State had a light bulb moment after Caba II. Insofar as the respondent referred to paragraph 54, you'll note that the words there were, there is no express limitation on duration. That also was known by the United Kingdom, and despite that, the word period for which it may remain, and I'm going to take you back to that, was used in the legislation. So I have nothing more to say in relation to that. If you're further interested in this case, the respondent sets out their submissions on it in their detailed grounds of defence at paragraph 43 onwards. But we say Mr. Justice Eyre was absolutely right to say this is entirely irrelevant. My ladies, my lord, the 2023 Act, I think I've dealt with that. I'm not going to make any further submissions. Turning then to the question of the meaning of the word period in its statutory context. Yesterday we looked at both the 71 Act and the 81 Act, the Nationality Act and the Immigration Act, and we saw that the language was the same in terms of settled and period. And I took you to section 3 of the 71 Act, which showed we submit very clearly, certainly 3.4, that period means period of time. But I'd also missed in my submissions while I was going through section 51. It's at Authorities Bundle tab 42. Page 718. Sorry, it's 10. It's 50 subsection 10. We'll see that actually period is defined by reference to time, from or to a specified date. A period from or to a specified date includes the date. Now, I'm also, in the point I'm going to make in a moment, going to deal with a 1972 Ireland order to explain to you something in relation to indefinite leave to remain. The other side were given it, and I explained the submission that I was going to make in relation to it. But of course, if the respondent wants to come back, of course it's your prerogative, but I would have no issue in relation to that. But the 1972 order that I'm going to show you, and perhaps actually we might as well just open it up now to make this point. And I'll explain to you why it's otherwise important. This Irish citizens, as part of the common travel area, can come to the UK without any immigration control. So they are exempted, like diplomats, soldiers, etc., from the Immigration Act, but not in the context of the EU, but in the context of the Common Travel Area, which preceded EU accession. In order to deal with that position, the Secretary of State issued an order to deal with people who come through the Common Travel Area. And in this order that you have in front of you, you will see various references to time by using the word period. And that's the only point I take it to you to now. So it's section 3A, which is on page 7 of 18. you'll see 3A subsection C, purpose of a stay of a period of 9 days, 90 days or more.
Sorry, can you give me that reference again?
Sorry, it's page 7 of 18.
7, yes, thank you. Yeah, 3A,
3 capital A subsection C.
thank you.
You'll say a stay for a period of 90 days or fewer. And then if you turn to the following page, you'll see 4B, limited to leave to remain, which has since expired, which we say can only refer to time. It cannot refer to qualifications. Qualifications or conditions do not expire, applying a normal reading of normal English. And then 4.4, the restriction and condition referred to 3 are the period for which he may remain in the United Kingdom shall not be more than 6 months from the date on which he entered, again using that language. And then after leaving, page 13 of 18, 5, subsection A, little Roman 2, again the use of the word expired, and then the same language at the bottom of 5, the period for which the person may remain. And then if you go to 15, you see exactly the same in 6, etc., etc. Now the point is that this was a 1972 order. This was adopted under the Immigration Act. The language of the Immigration Act is the same. It was adopted in the British Nationality Act. In the Immigration Act, the period for which he may remain is a time period, a period which may expire. It is not a condition or qualification. And we say that that is normal English language, OED language, your first touchstone for statutory interpretation. Next point on this, we submit that 3 categories of time do not exist. So contrary to the suggestion yesterday of Lord Justice Phillips, we do not agree that there is a definite period, an indefinite period, and an unknown period. We say that an indefinite period is an unknown period. And indeed, in the context of indefinite leave to remain, that is an unknown period, because an indefinite leave to remain is not the same as right of abode. It is not the same as citizenship. It may indeed come to an end. It is an unknown or indefinite leave to remain. So we say that applying a proper and normal approach to statutory interpretation, there is only one option open to this court in understanding the period for which he may remain, and that is a definite, known or definable period of time. And in that sense, one could say that Komarasu was a definable period because it related to a specific job.
Why is that any definable any more than for so long as you are a qualified person?
Well, we say it's a definable because a job necessarily comes to an end. So in the case...
So does being a qualified person?
Well, it doesn't, actually. Because a qualified person can go on effectively...
Until they die?
No, it can go on, for example, to retirement.
Or setting a job?
Yes, but that's exactly the point. He would not have been able to stay at retirement age.
No, but we're talking about period.
Yes, but it
and
is
what
definable.
What Komarasu said is that even though that was not a specific point of time, a specific period of time, or a defined period of time, it was nevertheless a restriction on the period.
Yes, but our submission is that period, at the very least, you can say will come to an end. Now, I'm not talking about death, of course. That
Forgive
is.
me, I'm
I'm
really sorry.
about-
You're saying that Komarasu can be regarded as a defined period of time.
I'm saying it can be distinguished. Facts of Komarasu can be distinguished from the facts in relation to someone exercising EU rights. So I'm saying that the facts of that specific case, interestingly, you will have noted from the judgment that when he was given the correct stamp on his passport, he was given 12 months. The incorrect stamp was stating that he worked at the High Commission.
Yes, but what the Court of Appeal were considering was the effect of the incorrect stamp.
Yes, and what they said was while he occupied that job. Now, we say that this court can distinguish the definition of that from an indefinable period of time, which would be remaining a qualified person. And the reason we say that's indefinite is because it could be indefinite, while the occupation of that job could not be indefinite. If he retired or got sick, that period of time would come to an end. In the case of EU citizens, that is simply not the case. They are in the same position as people effectively with indefinite leave to remain. Their qualification may end. So if you have indefinite leave to remain, your qualification to remain may end. Yes, as my junior says, comarasu ends with a specific and identifiable event. And in that sense, we say that you can distinguish it.
But it's still not a defined period of time.
Well, I don't think I can help you any further. I would say
No,
that it's.
I don't think you can.
I mean, we can continue. Our submission is that if your permission ends with an identifiable event, which is identified in the permission,
You've just been sharing this authority, other provisions which refer to a period of time, and 12 months, or you refer to show us 5010, which says days from to, etc., etc. Your case is, as I understand it, that we should read period as meaning a limited period, as in limited leave, as in Section 3 of the Immigration Act. But that's absolutely not what comarasu is. It is the interpretation in comarasu, which is saying that it is restricted on the basis of restriction not for a defined period, but whilst something occurs. And that's exactly the same, as far as I can see, as a restriction whilst you are a qualifying person. They're different, of course they are, but in neither case are they, as per your argument, a specific period of time.
So my argument on the correct interpretation is effectively, I take your point, that effectively says that you have to have an identified period, and to that extent...
Well, that is your argument.
Yes. Well, that is what
it.
We say that period means ending with an identifiable point in time. Yes, and that's what we say the correct statutory instruction.
Yes. And that's not comarasu, is it?
No.
No,
and
thank you.
That is the position we say is the correct statutory interpretation. We say that comarasu was per incuriam. We say that you can distinguish it.
Well, that's to keep those separate. Per incuriam, you say we should ignore it because it didn't refer to certain statutory provisions. And that's one argument. But let's assume it's not per incuriam. You say we should distinguish it because, as I understand it, you say that in that case there wasn't a defined period of time, but there would be a definable endpoint.
Yes. So we say you distinguish it. If you don't accept the per incuriam point, we say that you then distinguish it on the basis that period must mean that it ends with an identifiable event as identified in the permission, right? In the actual permission.
But why isn't the coming to the end of that employment the same sort of identification as somebody who ceases to be a qualifying person because they have ceased to fit within the regulation, the list of things which are in the regulation? At the moment, I fail to see any distinction as a matter of principle.
Well, I can only repeat my submission, which is that you know that one is going to happen. A job will come to an end. You cannot get sick or retire or whatever. You will not be able to stay here.
But that would just be moving from one ground of qualification to another ground of qualification.
Yes, well, I take your point. I can only repeat. That is our argument on the basis on which you
I mean, a person
can
who
distinguish.
qualifies because they are a student. I know some people remain students for a very long time, but presumably you can say that a student will cease to be a student at the end of their course.
Yes.
Why is that not the same?
And then they might become a waitress.
Yes, and they might cease to.
And then they might have an accident serving cappuccino or whatever, and then they could stay. So I am simply saying that it is open-ended. It is effectively open-ended, and therefore it is not defined in the permission to enter and remain. And that's based on which I say you can distinguish Kumarasu and why the court came to the conclusion it did. Because if you remember, stamp in the passport didn't say anything about time. It said he works at the High Commission. Right? So actually, and it's another submission I'm going to make, ironically, he fell within the exemption, which was another error. I know you're not allowed to look at errors. There's another error in the judgment, so he fell within the exemption, and therefore he was not in any event entitled to claim settlement because he fell into an exemption that didn't allow you to stay forever. Yes, and it said to me that Kumarasu effectively, if it's read in the way my lord suggests, proves too much because it effectively means that it covers ILR as well. Because as I've made the point before, ILR it's indefinite leave to remain, meaning it's unknown leave to remain. It comes to an end, or it can come to an end if the relevant conditions are no longer met. And even citizenship.
There's only limited leave to remain that can be made subject to conditions.
Yes, but indefinite leave to remain can be brought to an end if you breach some...
certain citizenship.
Citizenship can be removed.
Yes.
Citizenship can be removed. Are we going to say that that's an indefinite leave to remain? No. Well, we know at least there's a right to vote. It's effectively... if citizenship can be revoked, and if you can be deported on the basis of revoked citizenship, there is no such thing in this country as a period in which you may remain without potentially losing that entitlement.
Well, isn't that the point that the Secretary of State is making? That there is a restriction. Unless you have abode pursuant to the Nationality Act, there is always something that could deprive you of your right to remain. So, are we dancing on a pinhead?
Well, no, because if that's right, then Section 11B should say that your child will only be British if you're a British citizen or you have a right of abode.
But why does it need to say that? Because it's providing for the opportunity for someone who is settled to nevertheless imbue their child with British nationality if either they are settled or the mother or father, the other parent, was a British citizen.
Yes, because if one defines settled and a restriction on period, if we say for period, if we define that as to mean not subject to any potential basis on which you could be deported or lose your right to remain, that includes ILR, that includes citizenship.
Well, that's why we go back to this application that I was asking Mr. Blundell about, which he says, Regulation 5, if someone is entitled to say, now I want to be, as it were, earmarked as settled in advance of pregnancy or in advance of anything else, that this is the way to do it. You apply, you get somebody to confirm that you've not only got ordinary residence, but you've got the connection, the sufficient connection.
But that's a very different question because the Rule 255, entitlement to have your residence permit endorsed, is to show that you, the mother, have a right to residence, not settlement or whatever. It's a separate right to residence. Okay. There is that also could be revoked because it's presumably like ILR. The question we're concerned about is who did Parliament intend did Parliament intend that the EU nationals who are ordinarily resident here, and if you look at the language, not subject to restrictions as to the period for which they may remain, did Parliament intend that if they gave birth here, their children, not the mother or the father, but their child should be British? So when they sign up for school,
you're just reciting the issue that we're trying to decide.
yeah. So why I don't think it's dancing on a pinhead is because effectively the respondent's argument proves too much. And Kumarasu does too, because effectively what it says is that you can never be settled.
I don't think it is. I don't think it's suggested that rights such as indefinite leave to remain would fall within the rubric of restriction on the period. The fact that something could be revoked doesn't mean it's subject to a restriction. It just means that there may be circumstances in which it could be revoked.
Well, that I would respond to that, my lord, in saying the same as you said to me, which is that there isn't a logical distinction. And we're not concerned with policy. We're not concerned with what the Secretary of State may or may not think or do. We are concerned with the actual words of the statute read on an objective, not a subjective, an objective basis. What did they mean?
Well,
what do they mean?
It boils down to this, doesn't it? What the way as Anne responded is that there's a restriction on the period. If you can only be here for 5 years, that's a restriction on the period. Or if you can only be here so long as you are a worker. And that's what Komarasu said.
Well,
and that is what the claimant's mother in this case was, a worker. And the difficulty one has is distinguishing between Komarasu, who said that there's a restriction on the period if you can only be here for as long as you are in this employment, and the right of a person to be here for so long as they are a worker.
But I take you back to the role of the court in statutory interpretation is not to read words in. It is to read what Parliament intended objectively. Now, Komarasu did not say that he can stay as long as he's a worker. Komarasu said he can stay as long as he works in the High Commission. That comes to an end, he's out. Now, he never worked there, by the way, and therefore he was not allowed, he was allowed back in on a 12-month permit, but he couldn't get anything from the fact that he had been allowed to work at the commission, said to be working at the commission. It's a very different, we say it's a plainly a finite period. Now, I'm not sure I'm going to make any progress because we obviously disagree in relation to that. But I say that those circumstances can very easily be distinguished from the very different circumstances of the indefinite entitlement of EU workers to come and go to the United Kingdom.
Can I ask you, in terms of reading words in, have a look at Stevens, paragraph 36, it's page 620 of the authority bundle, where the learned judge said the applicant submits that not subject under the immigration laws to any restriction on the period in which he might remain in the territory means not restricted under the immigration laws to a definite period of time for which he might remain in the United Kingdom. And that is, I think, the reading that the judge upheld. Now, am I not right that that is your submission? That's how it should be read.
Yes.
But isn't it you who's trying to rewrite
Well,
the
no,
statutory language?
because I've taken you to the definition of period in the 1971 Act. I've taken you to Section 3. I've taken you to Section 50, subsection 10 of the British Nationality Act. I've taken you to the 1972 Order, which was enacted pursuant to the 71 Act. Time expires. Time limits for a specific period of time written in that order, adopted pursuant to the 71 Act. Now, that is legislation. That is not my words. And I repeat, we have to approach this on an objective basis.
Conditions can expire as well as time, can they not?
It's not natural. It's not natural language.
So what language would you utilise?
Well, you would say the condition is no longer compliant with the condition, or the condition comes to an end, or the condition, I don't know, whether you, if it,
Well, what you could say is, for example, suppose the Secretary of State said, I give you leave to remain on condition that you remain living in the embassy for His Excellency the Ambassador to Mexico. And when you stop living there, that the condition, I suppose, expired is a word you wouldn't use, but it wouldn't be wrong. Everyone would understand what you meant.
well, one thing I know about working with parliamentary draftsmen is they are very careful about language. We know that language is
I
very
think the
powerful.
courts would disagree with some of that.
Well, they certainly get extremely concerned about the implications of the risks of it, etc., etc. Now, I can only urge on you my natural understanding of it as a matter of English
all right.
language. My understanding is it means a period of time, a period for which, not a period during which a condition is met, but a period for which the person stays that may expire.
Well, a period always is a period of time, isn't it? There's no, you can't have a period that isn't a period of time.
No, it's
No.
a tautology.
So we're talking about time, but time doesn't. We often talk about periods which aren't defined. That's the problem.
Well, with greatest respect, we are talking about time, and that is our submission.
We understand. I understand that.
My second point is the Secretary of State's new interpretation of period, if it's correct, then it wasn't necessary for Parliament to have enacted Section 53, 50 subsection 3 or Section 50 subsection 4c. That is because, on the Secretary of State's interpretation, those individuals listed in subsection 8.3, 8.4b and 8c of the Immigration Act, 1971, i.e. soldiers and diplomats and those kind of people, they were subject to a restricted period of time on Lord Justice Phillips' understanding, a kumarasu equivalent, because they were only entitled to leave to remain for so long as they remained diplomats or soldiers or whatever. And therefore, if this is correct, 53 and 50 subsection 4, for another reason, are entirely odious. And of course, the rules of statutory construction is you should read the statute in its entirety, and relevant provisions should not be considered odious.
Well, I think you'd better deal with the point that Miss Blundell made this morning, which is the reason why there are those exemptions is because this particular group of people, so the soldiers, the diplomats, etc., are, unlike EU citizens, not subject to another regime. That's the point. He says that's why it's necessary for the legislation to define that exemption. So would you like to address that?
But I think that's it doesn't make any difference, because you wouldn't need to exempt them at all. In the sense that the exemption in 50 subsection 3 is that because they're exempted from the need to leave to enter and remain in the Immigration Act through section 8, that subsection 53 and subsection 54 say that that exemption cannot be relied on for purposes of settlement, establishing that they're settled. My point is that 50 subsection 3 and 50 subsection 4 would not be needed, because as soon as the exemption had come to an end, they would be returned to being under the Immigration Act. And therefore, they could no longer stay. Yes, I'm sorry. I got muddled up with the previous 53, 54 point. Can I start again? The 8.3 and 8.4 exemptions are not necessary. Is this right? Because there would be no need for such exemptions, in the sense that their entitlement to enter and remain are wholly dependent on them occupying that role. So therefore, their entitlement to remain is, in any event, dependent on that role. Yes. So the exemptions entitle them to be exempted as diplomats for so long as they are diplomats. And therefore you do not need the exemption in relation to settlement, because they could never, ever claim to be settled. Do you follow? That they would never, ever be able to say they were settled, because they would be restricted in relation to time. So if the Secretary of State's argument is correct, then they were always subject to the condition that they were a diplomat or a soldier. And therefore, by definition, that by the Secretary of State's definition, they were subject to restriction on the period for which they may remain. I'm sorry if I haven't made that. Has that argument been understood? Yes, thank you.
Yes.
Yes. So on the Secretary of State's interpretation, the individuals who are listed in 8.3, 8.4b and 8c would in any event have been subject to a restriction on the period for which they may remain. And therefore there was no need for any exemption under 53 or 54, because they could never have claimed to be settled under 50, subsection 2. So I want to turn now to the relevance of Rule 255 and the decision through the immigration rules to grant EU nationals a permanent right to remain after 4 years here. And that was a purely domestic law decision. It had nothing to do with EU law. Now, our point in relation to Rule 255 is not that the mother should be treated as if she had applied for a residence permit.
I'm really sorry. Can I just go back to that last point? One of the things that we've been discussing during the course of the last day and a half is the right to enter without hindrance and to work without discrimination for an EU national. Now, just thinking about the exempted personnel, isn't the corollary that what you're looking at is the fact that their entry and remaining in the jurisdiction is by virtue of their job, their post, their role? So, in terms of settlement, you're saying, well, they could never have claimed settlement anyway, but I'm not sure that's right. Unless they were exempted. So if they weren't exempted, why couldn't a soldier who says, well, you know, I've been assigned to the diplomatic service for the last 15 years, and I've lived here, I've made a life here, so my entry was facilitated by the fact that I was a soldier. And my position has been regularised by the fact that I was a soldier. And but for the exemption, I am settled. Because if it wasn't for the exemption, surely they'd be able to say to the Secretary of State, well, that's how I got into the country, that's why I remained in the country, but it doesn't mean that I wasn't settling here. And it's only the exemption that precludes it.
No, because the test for settlement under the Immigration Act is the same effectively as the British Nationality Act. And the question is whether they're subject to restrictions, subject under the immigration laws as to restrictions on the period for which they may remain. So the soldier would come along, or the diplomat, and say, look, I've been a diplomat here 20 years. My kids have been to school here, whatever. Who are not British, of course, because of being. But I want to be settled. And the question would be, is he subject to a restriction on the period for which he would remain? And the answer actually given in Kumarasu was, well, yes, because your entitlement to be here is only to remain, is only for so long as you're a diplomat or a soldier. And therefore you are subject to restrictions on the period for which you may remain. So you cannot be settled. And therefore you didn't need 53 and 54 if the respondent is correct. Because the respondent's argument means that no one who had a condition on being here could ever have claimed to be settled.
Thank you.
And that's why we say that, again, it tends towards, see, you've got to read provisions as having meaning, it tends towards the natural language, which it meant time period.
All right, well, I now understand your argument. Thank you.
Sorry, I was a bit
No, I
confused
just
the way
wanted, no, it wasn't. I just wanted to be clear. So thank you for that.
Well, there are two arguments under 53 and 54, and they're quite complex, but they both tend towards the construction that we submit.
Yeah. Thank you.
So then turning to Rule 255, so as I said, our point in relation to Rule 255 of the 1994 Act is not that the mother should be treated as if she had applied for a residence permit and to be endorsed, such that, as accepted by the Secretary of State, even under the Secretary of State's new interpretation, her son would have a British nationality. We're not saying that. Our point is that this rule is another element that shines a light on the statutory intent. And that is because it shows that Parliament's intention at the relevant time. As I've said, there was no EU right to permanent residence until the 2004 regulation that was implemented by the 2006 regulation. So prior to 2006 in the United Kingdom, you had no EU right to permanent residence, save incapacity and retirement. But despite that, in enacting the 1994 order and amending the immigration rules, the Secretary of State, as a matter of pure domestic law, conferred on EU nationals a right to permanent residence if they exercise free movement rights for 4 years. And that was a legislative decision that was in line with the exemption of EU nationals from the Immigration Act 1971, something that was, of course, required by EU law. So a decision was made as to the extent to which such individuals should be integrated into United Kingdom society. And children of EU nationals, ordinarily residents here and exercising free movement rights for 4 years, were to be granted British nationality as a matter of pure domestic law. And we say that was a domestic policy decision. And it's borne out in reality by what happened when people did move and settle. Their children were born, they went to school, they spoke English, perhaps they even didn't claim a passport of their country of one of their parents' birth. Perhaps they didn't even learn the language of their maternal or paternal tongue. And the respondent has said, well, it was perfectly legitimate for us to require papers, etc., to get an endorsement. Well, we don't dispute that. That is about the entitlement of the parent to remain. What we say is that the Secretary of State's decision to enact that legislation, granting a right of permanent residence, throws a light on the British Nationality Act itself, why it was drafted as it was, why there is no reference to EU requirements within it in relation to under Section 50 or anywhere else, why there is no definition in relation to EU laws. We should also note that, of course, the papers point doesn't go anywhere because the appellant had to produce papers to prove that his mother had been exercising free movement rights at the time he was born. And there would be nothing to stop the Secretary of State requiring those 4 or 5 years papers. They in fact did that. In fact, you'll see that that's the decision. We haven't had proof. That's subsequently been dealt with. But it is no answer to my point on statutory connection, on statutory interpretation. Connection may or may not be a test for citizenship. That is, as Mr. Justice Eyre said, it's irrelevant when we're looking at the statutory interpretation here. Our key point is, what did Parliament intend in terms of the children of EU nationals who were ordinarily resident here, working, caring, etc., exercising EU rights. So the next yes, I should just make the point that Home Force members are exempt, again, from immigration control. That's at section 84A. I did take you to this. I did make this submission in my opening submissions, but they are not subject to the exception in section 53. So they are capable of being settled. I think I referred to that specific one. So there is a strong indication that there are different categories. And the effect, if komarasu is applied broadly and not distinguished, is that those individuals in 84A of the Act would also not be able to have children who got British citizenship. So these provisions have to be read together because there are cross implications for reading period as meaning conditions that would affect other categories. Now, my point on the change from jus soli to section 1.1 of the British Nationality Act, we say without being subject to period for which he may remain is a matter of fact, or time restrictions is a matter of fact. Whether or not the status involves a time restriction. But those who are defined in the Act as being able to have children who can claim automatically British nationality, include those with a right to abode, so UK citizens, Commonwealth citizens, born prior to 83, and British subjects with the right to abode. Those with indefinite leave, with or without the right to readmission. Irish citizens, and I'm going to take you to the relevant bits on that. Those with an exemption from immigration control under Section 8 of the Immigration Act. Those with EU rights as excluded as provided in Section 7 of the 1988 Act, i.e. exempted. And children who were born in the UK on or after. Apologies, I just want to check something from behind if I may. So all of these categories, their children are born here, they get British nationality because these categories can be settled. They are settled. So children born in the UK, now the United Kingdom and Ireland and the islands, together with the Republic of Ireland, form a common travel area. And we find that in the Immigration Act, which we need to go to. It's in Section 1(3). So these individuals are taken out of immigration control. And if an Irish national, therefore, has a child in Britain, their child will be British, will have an entitlement to British citizenship.
Sorry, where'd you get that from?
That is a fact.
Right,
if the
okay.
respondent wants to come back on it.
Yes, I just wondered,
Yeah.
because we were looking at Section 1(3. So arrival in and departure from the United Kingdom on a local journey from any of the islands, that's the Channel Islands, Isle of Man, Republic of Ireland, shall not be subject to control under this Act, nor shall a person require leave to enter on so arriving, except in so far as any of those places for any purpose excluded. Okay, so this is the common travel area.
Now, those individuals are equally covered by EU law. They are therefore subject to the restrictions in EU law, or restrictions, I shouldn't say that, I should say they are entitled to the rights of EU law, and on the Secretary of State's case, they are subject to the restrictions in the relevant regulations.
Can you...
Despite that, Irish citizens are considered not to be subject to the restrictions. Now, in our submission, that is a clear basis for, the clear explanation for that is because the Secretary of State was always right in his interpretation of what Section 50 meant. It did not, in immigration laws or in definition of period, intend to cover EU rights and obligations, nor it was concerned with the 1971 Act. I'm going to come back to that. And that follows automatically because if the Secretary of State was right, then children born to EU citizens would be subject to the restrictions in the 2000 regulations or the 1994 regulations. Sorry.
I've completely lost this argument. I'm sorry.
Can my junior deal with this point?
Yes, of course.
My lady, I'm grateful that the submission goes to ground two.
Yeah.
And Mr. Blundell's King Counsel's point about what constitutes a real and substantive UK connection for the purposes of the definition of settled in section 1.1 of the British Nationality Act.
Right.
And the primary contention has been that if you enter the country, you have a period of limited leave to remain, and you achieve permission to reside here indefinitely. And that's one journey. The submission in relation to Irish citizens entering under common traveller area arrangements is similar to the submission we made in our skeleton argument about paragraph 58 about Commonwealth citizens with the right of abode. And it bears on the High Court judgment in paragraph 106, which is at page 91 of the bundle, where Mr. Justice Eyre deals with this question of conditionality. Is the possession of Commonwealth citizenship, whereby you have the right of abode, that is a condition without temporal restriction. It is a condition you have to remain a Commonwealth citizen with the right of abode in order to enjoy the benefit of that. And if you have that, you enter without restriction as to time, regardless of whether you have previously been in the UK. So there's a category of people who have that quality, if you like. And to give you an example, if your mother was born in the UK prior to 1983 and you were born in Australia prior to 1983, you're a Commonwealth citizen with the right of abode. And you would enter the UK, and if you're ordinarily resident here, you'd be here without time restriction, and say after 2 or 3 months you had a child, that child would be a British citizen if you were ordinarily resident. Position with an Irish citizen with a common travel area exemption, section 1, subsection 3, is the way that the common travel area works is that it creates a zone of mobility without borders, and included in it are the United Kingdom, the Republic of Ireland, the Channel Islands, and the Isle of Man. Everybody is free unless restrictions are imposed on them. And so the two sorts of people might come from Ireland: Irish citizens and aliens, foreign nationals. Aliens are then subsequently controlled by the 1972 control of immigration through the Republic of Ireland order that we looked at, that Ms. Simon King's Counsel took you through. Irish citizens are not. They remain free of any immigration control restrictions. And so when they come into the UK, potentially having never lived in the United Kingdom before, because they've been born and raised in the Republic of Ireland, the moment they are ordinarily resident here, they are free of time restrictions, and if they were to have a child, that child would be a British citizen under section 1, because the parent would be settled in the United Kingdom. The definition would be established. And so there is, in distinction to people who come into the UK, get limited leave, who achieve permanent residence, which is the sort of mode of thinking that we always think of as becoming how you become settled in the UK. There, like the French worker in this case, there are two other sorts of people who possess qualities which give them the right to be here without time restriction. The first is an Irish citizen who comes to the UK and is ordinarily resident, and the second is a Commonwealth citizen with the right of abode who does the same thing. And so there are analogies to a French worker coming into the UK, two other categories, and they would have been apparent to the parliamentary draftsman, to Parliament when it enacted section 1.1 of the 1981 British Nationality Act. And so there are people who have not gone through that journey of limited leave to permanent residence, who nonetheless are considered settled. And both of them need to possess a particular quality. In the Irish case, it's possession of Irish citizenship, and in the Australian case, it's possession of Commonwealth.
Right. What this all amounts to is what you're saying is that Irish citizens there is no restriction on their period the same with a Commonwealth citizen.
who has a right of abode under particular.
So, and from that point, you draw what? That
There are a category of people who can be considered settled, who have not expressly been given permanent residence, whether under EU law or under the grant of indefinite leave to remain.
yes.
And that settled, what Mr. Blundell King's Council's submission was that you needed to have a real and substantive UK connection. Our submission is that we don't necessarily disagree with the idea of that formulation, but it can include people who have not got a pattern of in-country journey to permanent residence. They've recently arrived.
But that's a policy decision on the part of Parliament that Irish citizens and Commonwealth citizens in those circumstances should be treated as having a connection because of the historic connections with this country.
It is a policy decision, but the conditionality is that you must possess Irish citizenship or Commonwealth citizenship of one of the Commonwealth countries. And say the point is that there may be people.
What is your point at the end of the day? You say, well, in fact, it is restricted because it's restricted for so long as they are Irish citizens. Is that your point? The condition is not a temporal one. It's a quality or possession of a characteristic, if you like. And in the appellant's mother's case, it was that she is an EU citizen worker, and in the context of the Commonwealth citizen, is that they have a mother. But we have a qualitative difference here, that the Irish citizen has an unrestricted right to be here, whereas the EU worker is only entitled to be here so long as they are at work, or some other. And that's the difference.
We say that they're both non-temporal conditions, and that once you establish the principle that there are non-temporal conditions which have applicability, and it's not simply about time limits, and of course there will be different circumstances as to when they arise, but they are all non-temporal. They hold that in common.
But wasn't that, Mr. Berry, the point that the Secretary of State relies on, that we're not just talking about temporal limits here, we're talking about events or characteristics or qualifications that define a period. So I don't know that your argument undermines what that submission is.
We would say that what we need to establish is there are other ways in which that there are restrictions on, if you like, on your ability to be here, which are not defined by your temporal condition, but which are defined.
No. So, but you've drawn our attention to the fact that an Irish national, and I don't know what a resident of the Isle of Man would be called, a Mancurian.
A Manx, but they would be a British citizen.
Yes, but I mean, so Section 1, subsection 3 makes it clear that they're fine as long as it's a local journey to come and go.
Yes.
And then subsection 5 refers to Commonwealth citizens who were settled in the United Kingdom at the coming into force of this Act, and their wives and children. So again, that provides the connection, the historical connection, as my lord has identified it.
My lady, for the purposes of your note, Section 1, subsection 5 has been repealed in 1988 and relates to a different.
Yes, but we've been invited to look at the 1971 Act to see what was in the minds of the draftsman when it was drafted.
Yes,
so
indeed,
it was there then. That's the only reason I'm putting it in. But the fact that there are these differences, I don't. Perhaps you can answer my lord's question. I mean, so there are differences. So what?
They're non-temporal qualifications. That's the only point that we make. You have to say some people, an Irish citizen, in order to acquire, say, the nationality of another country, may have to renounce their Irish citizenship because a second country is intolerant of multiple nationality. They would cease to be Irish, and therefore they would cease to benefit, self-evidently, from the common traveller exemption, which applies to Irish nationals. And so too for the Australian who naturalises, say, in another country, Malaysia, Malaysia's Commonwealth, but another country which is intolerant of multiple nationality. So these citizenships can be lost for reasons other than deprivation of citizenship.
I think what you're trying to suggest is that if what you're trying to say is comarasu cannot be intended to have the effect it's been suggested, because that would mean that Irish citizens would not, as you say, is the accepted position, that their children would not be British.
That is, in some senses, correct, my lord. Yes, yes. And if I can pursue that just one stage further, my learned friend, Ms. Samuel, King's Counsel, mentioned the question of people in the home forces who fall within Section 8, sub 4A of the 1971 Act. They're not excluded under Section 50, subsection 3 of the British Nationality Act.
You say the same applies to them.
Exactly.
Yeah. I think we really have got these points.
My lord, I'm simply elaborating the common travel area exception.
And at the end of the day, the answer to it is it depends on the interpretation of the word restricted.
May I just ask a particular?
Yes. Well, only if you need it.
Okay. So these.
So, I wonder then if you can. Now,
I can finish my quarter past.
yes, if you can,
Yes.
certainly we think you should, because some of
Yes.
necessarily, I'm not being critical. Necessarily, we sometimes do go over the same ground.
No,
again.
I take your point.
But yeah, but let's say
So if
thank you. First of all, thank you very much, Mr. Berry. Thank you.
So I just want to make a supplementary point in relation to Mr. Berry's
Yeah.
position. I just wanted to check that I had correctly understood the position. The Irish are taken out of the Immigration Act by Section 1.3. They also have an exemption. They are not exempt from the 2000 regulations. It follows that in order for them to continue to exercise their rights outside of the Immigration Act, etc., and not be restricted pursuant to immigration laws, the immigration laws cannot include EU law, as in the definition in Section 50 of the. So, if they are subject to the 2000 regulations, the 2000 regulations are immigration laws. They would not be able to be settled. Their children would not be British. The immigration laws mean the 1971 Act, but I'm going to actually deal with that point. I'll deal with that point now. The Immigration Act, we say, the Immigration Act 1971 is, is the Immigration Act. Regulations, we say, are not immigration laws. And Lord Justice,
the immigration rule.
yes. So no, not the rules. The rules are enacted under the Act, under Section 3.
You mean
so,
the 2000 regulation?
Yeah, we say when you talk about the Immigration Act, by virtue of the Interpretation Act, it also includes legislation adopted pursuant to it. So the 72 Order, the rules, etc. So that's the Act. But Lord Justice Phillips said that if the 2000 rules are immigration laws, then that means period must include EU law conditions, and therefore, it cannot be period.
Well, I don't think it must, but I
No,
think it would be a pointer.
Yes, could point towards the fact that the word
Yeah.
period must, or could suggest conditions. And otherwise, EU citizens would not be subject to any restrictions, effectively, because they're not subject to specific time restrictions, they're subject to conditions. And we submit that that would be equivalent, to make the equivalent mistake that we say McCloskey made in paragraph 19 of Caporelli, namely to say because a particular group is not subject to restrictions under a normal statutory interpretation, we must read the statutory interpretation in such a way as to make them subject to restrictions. So we say that would be an incorrect approach to statutory interpretation, and we would make our submission that would be wrong. So turning then to the question of similar purposes, and we perhaps should return to section 50, which again, it's right at the back, AB 42, page 716. Now, I want to make the comment that at the time of the British Nationality Act, the only Immigration Act was the 1971 Act. And interestingly, it is still in force. The only act that it took another 17 years until the 1988 Act was enforced, and that was the act that exempted EU nationals from the 71 leave to remain provisions. Now we say that tends again to our construction of section 50 immigration laws, which is that what Parliament meant here was the Immigration Act and any law for purposes to that act which is for the time being or at any time has been in force in any part of the United Kingdom. So they use United Kingdom twice in that sentence. And they do that for a reason. This is a sort of chancery type argument, but it is important in our submission. If you read that in definition properly, what it is addressing is a situation where legislation is applied in other areas of the United Kingdom. And what it's talking about, and the reason it uses the word similar, purpose is similar, is because it's not the Immigration Act that's going to be applied in Jersey or Guernsey or the Isle of Man. It's immigration, an immigration law with similar purposes that is applying elsewhere. And that is supported by B, which does the same thing. Now, the 71 Act could have been extended in its own terms, and it applies in relation to other territories. So there was no other immigration law. Now, when in 1981 the UK brought the Parliament brought in the British Nationality Act, it of course only knew about this act because there was no other act, but it did know that we were a member of the EU. At that time, of course, there was no implemented EU law in domestic law at all in relation to this. The way the Secretary of State dealt with it was through the discretionary powers under the 71 Act. In 1988, the Parliament took EU nationals out of this law, didn't then specifically amend the 81 Act to make clear that they were nonetheless covered by European Community directly effective rights, because again there was still no UK implemented law in 1988. First time we had any UK implemented law was 1994 with the Order, and at that point you'll recall that the rules were also amended to take EU nationals out of the application of the immigration laws. So there was no domestic EU law until 1994. And if the Secretary of State is right, Parliament is somehow to have intended, when taking EU nationals out of the application of this Act, to have believed that there was some unknown law out there that restricted EU nationals. Now, in my submission, that is extremely unlikely that any such decision was made. had a decision to that effect been made, it would have been made explicit in the legislation. So we say it's not credible that Parliament intended to provide a whole raft of potentially directly applicable laws that were unknown under the treaties, etc., and somehow divine what those restrictions were. And of course, being imprecise causes potential chaos, and chaos in these circumstances is not good. So to conclude, my lords, you are faced with working out the intention of the legislature when it enacted the 1981 British Nationality Act, a question of statutory interpretation only. Your job is to carry out an objective search for the intention and must be imputed to the legislature by reference to the meaning of the words used and the context in which they are used. The Spat-Holmes objective concept. Our submission is that applying the ordinary meaning of the words read in their statutory context, namely the overall structure of the Act and the position in the relevant connected statutes, the meaning is plain. And that meaning, we say, is the meaning that the Secretary of State applied for 17 years, namely that an EU national who was ordinarily resident and exercising free movement rights was not subject under the...
I think you're just making a speech now, if you'll forgive
Okay.
me for saying so, Miss Simon.
Well,
You're supposed to be responding.
I'll just finish. I just want to make my closing points.
Well, you're not entitled to a closing speech. You're supposed to be responding to points made and argument against you. So have you responded to those points
Well, let
that
me
you wish
check.
to?
It's really a summary of my points. I
No,
know that there is-
no, you don't need to summarise them for us. If you've made your points, that's fine. But we're not going to permit you as closing speech. This isn't the time for rhetoric. It's a time for argument and submission.
With great respect, I am trying not to make...
Well,
to be
your
rhetorical.
last 5 minutes has been a speech, I'm afraid. We've got the points that you've been making. Are there any further that you want to make in response to the arguments that Mr. Blundell made on behalf of the Secretary of State?
No, my lady, I may conclude, because that was all a summary of our submissions. I will not bore you with them. Our submission is simple. The words and structure of the statute, read objectively, viewed in context, mean that we haven't understood them correctly.
Thank you very much indeed. Mr. Blundell.
Yes, my lady. There's obviously a new point being raised about Irish citizens by Mr. Berry.
Yeah.
I don't want to tax the court's patience. It seems to me the court has the essential answer, which is that the position with Irish citizens is, for historical reasons, entirely different and has been treated differently, indeed recognised by the EU as being different. In addition, given the position of Irish citizens that they're taken outside the control of the Act altogether, if the purpose of relying on this point is to meet Kumarasu, it can't do, because with Kumarasu, that was looking at restrictions under the Act. And of course, the whole point about the settlement definition is you look at restrictions under immigration. So we say it goes nowhere at all. The one point I would like to make is that common travel area in relationship with Irish citizens and how they're treated obviously involves some fairly deep waters. I wouldn't want it to be thought that the lack of a further substantive response from me indicates that the Secretary of State agrees with everything that's been said about their legal position. I'm not seeking to say any more about it as long as that is understood.
Right. I think we understand that there may be many more debates about that
Yes.
in the future.
My lady,
I'm
I'm
grateful.
sorry, I have an anxious solicitor behind me because I failed to just clarify the position in the second in relation to the unagreed bundle. She's under the impression that I somehow suggested that it was not before the court and should have made an application or some such. As far as I understand, the other side doesn't object particularly. I don't know whether it's an issue. Her position is that the court needs it in front of you.
Well, we don't need it actually. I mean, the anxiety is obviously relating to costs. I've got no doubt. But we don't need it. We're very grateful that it was prepared, but it was.
Well, I don't think that the anxiety is in relation to costs at all. I can tell any of the costs.
So what
in
is
no
the
sense.
anxiety then?
Well, my
You have made no point on this.
I am instructed that it should be in front of the court.
Well, explain why, when you have made no point on it.
Well, my submission is simply that, in my view, the specific documents are not relevant to the exercise you have to carry out. My instructing solicitor would nonetheless like you to have.
Well, that's quite different from it needs to be before the court. She may like it to be before the court, but if it is not relevant to any point in the appeal, then it is not necessary. Thank you very much.
All rise.
Oh, forgive me. We're obviously going to reserve our decision. The usual process will be followed. We will endeavour to get our judgments to you as soon as possible, but there is obviously quite a lot to consider. So please don't sit and hold your breath on this. Once we have the drafts to you, please can you have a common document dealing with any typographical errors and any glaring errors of fact. Other than that, it is not the opportunity to engage in further legal submissions. I'm sure that counsel know that, but I make it clear. And if possible, please can you prepare a draft judgment and any further order. Sorry. I'd be very I doubt you can prepare an agreed judgment, but an agreed order. But we will also need, please, to consider any questions ancillary to this on the papers, if at all possible. If it's not going to be possible to do so, we will call you in again, but I'm sure that we can deal with it on the papers. Thank you both very much. Sorry, thank you all six very much, and your instructing solicitors.
Court rise if able.